this Caron?
May it please the Court, my name is Owen Gallagher, and with me is Carol Lazarley, my partner. We represent Horace Mann with regard to this appeal from the Superior Court. We're here because the Superior Court struck an endorsement to a homeowner's insurance policy that Horace Mann had issued to their insured, the Fowlers. We're here because we believe that the judge, in making findings that this was based upon mutual mistake between the parties as to what was to be in the policy, was erroneous because it did not have full, clear, and decisive proof of a mutual mistake. This is a routine insurance policy case in which arises out of something very simple. Horace Mann is what's called a direct writer. They have employee agents. They're not independent agents. They work for the company. They go out and solicit and sell only Horace Mann products, with some exceptions. Anything that Horace Mann itself sells, they sell. There are some other agreements relating to other types of policies, but basically they sell for Horace Mann. The Fowlers in this case were in the FAIR plan, the residual market in Massachusetts, and paying an exorbitant premium based upon their budget. The reason they were paying this exorbitant premium was they had had a total loss in 2002 of their house. It had burned down.
Mr. Gallagher, did under the FAIR plan, was there a uniform standard policy?
As you may know, Your Honors, there is an entity that has policy forms for a lot of companies called the Insurance Service Office, ISO. They use an ISO form. Horace Mann does not use an ISO form. They have their own form. So they have a standard form.
It's a private entity. It's not. This has nothing to do with the Commissioner of Insurance or nobody else.
Absolutely, Your Honor. It's just for the convenience of the industry. There are companies market policy forms that companies adopt. They then take the forms to the Commissioner of Insurance, and generally, when one gets approved, of course, it's much easier because I'm using a standard form.
Yes, so it's a standard, other than coverage limits, it's a standard form for all people getting policies under FAIR?
Well, there are, I'm not an expert on ISO, Your Honor, but there are a number of endorsements that ISO will put out at various times. And, of course, the companies themselves that use the ISO system are not barred from making their own forms.
All right.
Horace Mann is in a different situation. They have their own forms. As you can see, there's no ISO copyright in the record on their forms.
But I'm trying to flesh out the issue of what it means to say that Horace Mann is responsible for the conduct of its agents. So let me give you an example that I know is not the facts of this case.
Yes,
okay? Sure. Let's imagine Ms. Bode was her name? Ms. Bode, let's imagine a situation in which Ms. Bode says to Ms. Fowler, oh, you have a dog. Well, you should know that our policy will provide you $250,000 worth of coverage in the event of a dog bite. Okay? It's wrong. Would you say that that statement would be enough for mutual mistake or simply for negligent misrepresentation?
It would be both, Your Honor, because if, in fact, the contract was issued with a different endorsement, the party could, in that case, go forward on the basis of mutual mistake, saying that was the contract that was made. We cite in our brief the case from Maine where, in fact, the agent did that. They issued something saying, you're going to get this policy form, which the company didn't issue, and they were stuck.
Okay.
So
their mutual mistake would apply?
Yes, Your Honor.
Okay.
We are bound by our agent's acts. There's no...
And I guess let me now change the hypo, is that Ms. Bode does not say that, but Ms. Bode herself thinks, because that, which I guess is the facts of this case.
That is the case, yeah.
That she thinks that they have $250,000 of policy because she is not aware of the limitation on liability. Does the fact that she thinks it bind the company?
We say no, Your Honor, unless there was some type of communication that resulted in a contract between the parties, explicit or implied.
If Mrs. Fowler, arguably, I mean, it would be a different case. I don't know what, you may come out the same way, but if Mrs. Fowler herself had said, she did say we have an American pit bull, American bulldog, but she'd said something about, I'm concerned about that. And Ms. Bode kind of didn't say anything, but was kind of going on her misunderstanding of the Horace Mann policy.
There are 3 claims in this case. 2 of them still reside in the Superior Court. One of them is negligent misrepresentation. The position I would take, Your Honor, is that that is not mutual mistake. There may have been a duty to speak. Generally, an agent doesn't have a duty to speak, but if there was a duty to speak and the jury or the fact finder found they had a duty to speak and there was damages as a result, that's a different case than saying, as here, that basically our soliciting agent is making a contract that is fundamentally different than what's being sold. So,
Well, how is a consumer to know if they can't rely on what the agent says?
well,
What are they to do? Call the home office?
well, actually, the form, Your Honor, did have a number and a form to say call.
Is that your position?
No, Your Honor, I think what we have to look at is the law. There's 2 types of agents. You have the soliciting agent who is an employee of the company, and you have the independent agent. And the independent agent under our law does not have a duty to make sure that the consumer has the correct insurance or the insurance is adequate. They are acting as basically brokers for the insured. We are at an even higher or lower level because we are basically selling a product to the insured through captive agents or for employee agents. And if, in fact, you say there should be a duty to disclose these conditions to the insured, that certainly is your prerogative, but it is a real change in what the present law relating to the sale of insurance policies is.
So there was no misrepresentation here
That's
with
why
respect to this mutual mistake.
there is a claim for negligent
Right,
misrepresentation.
that's not here.
That's not here. All that is here is the separate entry of judgment for a mutual mistake saying that Ms. Bode and Ms. Fowler entered into a contract regarding essentially this endorsement. Or, well, I'll qualify that because it's very clear from the record that there was absolutely no discussion of the endorsement. We quoted quite extensively in our brief what Mrs. Fowler stated, that there was no discussion about the dog endorsement or liability of the dog, and Mrs. Bode also agrees. What is here on mutual mistake is sort of a higher order or higher level claim. That is, the person walked in, they solicited Mrs. Bode, Mrs. Fowler, to come down and give a quote, and Mrs. Bode asked for the Fair Plan Declaration page. The declaration page is not the policy. It's the listing of coverages and some endorsement numbers. She went through and basically went through and gave a quote for a Horace Mann policy. Mrs. Fowler stated the prime requisite was price. Well, the price was basically 40% of what she was paying for greater coverage on the home itself. There were these restrictions relating to the liability coverage. When she got the policy, the testimony was that Mrs. Fowler glanced at it, skimmed it, but thought that the $500,000 limit on the declaration page would cover everything, as she testified, just like I thought everything from under the Fair Plan would be covered and have complete liability. That's her part of the contract. The other side is, in one of the questions.
Well, but let me just back you up one step.
Yes, sir.
There is the declarations page, but aren't you also relying on the fact that the policy in its entirety had been mailed to her?
That's correct, Your
and
Honor.
it contained the animal limitations endorsement.
Absolutely, if I wasn't making that clear, of course. This was on top of the policy itself. And
You never saw the Fair Plan policy.
the policy itself, no, it's undisputed that she never saw the Fair Plan policy, the terms and conditions of the Fair Plan policy. That's Mrs. Bode.
Do we have in the record anything about the Fair Plan on dog bites?
It's not there.
It's not in the record at all.
Not in the
Whether-
record at all.
But let me ask you, this relates to Justice Spina's question. The argument that the Carons make on timing is what Mrs. Fowler did or didn't do when she received the policy is too late. What matters is at the time that they entered into the agreement of, back in March, back in Mrs. Bode's office, right?
Correct. The testimony with regard to the limit was based upon, in the record that I saw, was based upon the fact that when she received the policy, she thought she had a $500,000 limit. I'm sure that at the time, if there was she received a form that said a $500,000 limit. So I'm not making that as an argument. There clearly was a binder issued and signed by both parties
Right,
that had.
and that's the time frame we really should be focusing on.
I agree, Your Honor. It has to be this mutual intent at the time of contracting.
So that the fact that she was subsequently mailed the terms of the policy itself, including the endorsement, is irrelevant.
Well, yes and no, Your Honor, because as we argue in our brief, at the time when on March 10th, when they sat down and went through all the questions, there was a written binder issued, signed by both parties, saying that we are going to issue our standard policy. And there is that you're bound and you're going to get our standard policy. There's no dispute. The standard policy at that time contained this animal liability endorsement. So
And it actually went on to say, subject to the terms and conditions in that policy.
That's correct, Your Honor.
I take it none of the endorsements or limitations were discussed.
As far as I know in the record, they were not. There were a number of others. For example, there was social host liability. And based upon the judge's findings below, although the only claim was at this point, his findings were that because she was looking for a $500,000 liability limit, and my agent, Mrs. Bode, thought there was a $500,000 liability limit, that was a mutual agreement that could be the basis of mutual mistake and reform the agreement.
Let me just ask you, if there had been a discussion that basically the homeowner wanted to have at least as good coverage as she'd had in the FAIR Plan policy, and even if it wasn't, and that's what the agent agreed to provide, and that's followed up, let's say, by an email saying, I just want to have the same or better coverage, but for less money.
It really gets down to the question, in my opinion, Your Honor, of definiteness. At what point do you, for example, you have these cases from way back when where they said, I wanted full coverage. And, what was full coverage? And basically, there's always something missing. So the answer, such as it is it's really going to depend upon the particular
Really fact-dependent.
fact-intensive as to what's there. That's why this court has made it, so high, which is to say full, clear, and decisive evidence that you basically have entered into a contract, because obviously the whole system is based upon written contracts, not only with insurance, but anything else. And once people get written contracts and they say that the written contract does not evidence what the agreement was, well, especially when something has occurred which is detrimental to one party, you want to know that, in fact, when you're reforming it and setting aside that written agreement, that you really have the basis for it. The cases in Massachusetts, such as the Polaroid case, or even the older Shapiro versus Fireman's Fund, it was crystal clear that, in fact, there was...
But what's a little bit different here, maybe, is that the written contract was not delivered till after the agreement had been entered into. Is it your view that if a person reads the insurance contract after having signed the binder and paid the money, looks at the contract and says, whoa, this is not, I had no idea that there was a limitation on dog liability, that they're still bound by the contract, or that they can't rescind the contract?
You do have a category in accounting and insurance called policy not taken, where people go back and say, whoa, this is not what I wanted. They're still covered to the extent until they cancel the policy, but they go out and they get something else.
And the policy itself provides for that?
I'm sorry?
The policy itself provides
No,
for that?
it does not, Your Honor, but it does provide for the insured to cancel the policy. And obviously, if you cancel it after 3 months, there's a premium, but many times, if you cancel it right away, there's no premium. That's not in the record, but...
You'd get back the deposit, whatever she paid that
Right.
day.
The company says you didn't make a contract, that's it. But obviously, they'll try to bring it back to the date of the initial contract. They don't give you free insurance.
Right.
Thank you very much. We'll rest in brief.
Chief Justice Ireland, Associate Justices, may it please the Court. My name is Eric Parker, and with me is Lisa Scalisi, my co-counsel, and we represent the appellees, Scott and Caron. This Court should affirm the trial court's ruling in favor of the plaintiffs on 3 grounds. The first is that it's undisputed in this case, but that the facts fully, clearly, and decisively demonstrate that a mutual mistake existed in this case. The mutual intent and the understanding common to both Horace Mann's agent and Catherine Fowler was that the general liability policy would not be subject to a 95% reduction in the general liability coverage limits. And reformation of the policy by removing the offending provision is the appropriate equitable remedy here.
Well, it's clear that, I guess, that the insurance agent was mistaken about what the her product had as a limit. Was there anything in the record that suggests she ever communicated her understanding about that to your client?
Yes, there is, Judge Lenk. What I think you have to focus on here is the course of conduct that went on in the negotiations of this agreement. Clearly, there was no, to answer your question very directly, there was no specific question, by Mrs. Fowler, for example, do I have $500,000 in dog coverage for my dog? And the answer, hypothetically, by Mrs. Bodie, no, you don't have, or yes, no, yes or no. Mm-hmm. There was no discussion in that. But if we look at the record, it's undisputed that she comes to Mrs. Fowler Mrs. Fowler comes to Mrs. Bodie because she has a $500,000 policy with a fair plan. It's costing her a fortune under the assigned risk pool. And what she's seeking to do is not just save money, as it's been represented. She's seeking to get out of the assigned risk pool, which almost has a punitive aspect to it because of the cost of the policy. So she's going to get, and she expresses, she wants to get the same coverage that she had.
But we don't really know what that coverage was as to the dog bite stuff.
Agreed. And I just want to get back to your question, then I'm going to answer that. There was then a series of questions as part of a questionnaire. It's in the record. And it was an extensive series of questions, particularly regarding perils. And what the question was, and I'm paraphrasing, but pretty accurately, do you own a dog? Yes, I do. Is it a Rottweiler, a Pit Bull, or a Doberman? No. Okay, then, let's move on to trampolines. My suggestion is that that constitutes a discussion. I understand that the appellant has disputed the fact that that's a discussion. Whether it's a discussion or not, it really is not necessary to resolve here. Clearly, there was an exchange which led the policyholder to conclude, as any reasonable person would, that she came there to get the policy of like kind and extent. It's undisputed in this record.
Well, what would have happened if she brought in the declarations page? It said $500,000, and she got a new declarations page. She saw that, and it matched. But what she didn't know, and what nobody knew, was that that it even mattered to anybody, that there was a clause inside the policy that said, we will not cover for any animal injury, animal-caused injury. And yet, you'll look at if you compare the declarations page, you'll see $500,000 for liability and $500,000 for liability. What would happen in that situation?
I think that it would be very difficult to speculate because there's no uniformity among deck pages. Some deck pages list some of the exclusions, some list none. In this case, and I think that adds to the problem, some exclusions, not limitations, but exclusions were listed. And in the appellant's brief, they confess, and they're correct, that it was not complete. which creates even greater confusion for the policyholder. She comes to an agency, she sits down, she explains what she's looking for, and then the series of questions, you have this dog, that dog, or the other dog, and she says no, and they move on. If you looked at and by the way, the deck sheet doesn't come out the day of the contract. I just want to make that clear. That comes out later. What they get at that time is a verification of coverage page or binder, and that is even more vague than the deck sheets, and the uniformity among them is even more disparate.
But is that the document that also says subject to, this is what you're getting, subject to?
Yeah, that's not the deck sheet. Just to clarify, that's the binder.
Okay.
But
and,
I would
and does the binder have the statement that it's subject to?
Yes.
Yes, it does.
Okay.
That's undisputed.
Okay.
But what I think is so misleading here is that what the record clearly shows is that Mrs. Fowler made it clear to Mrs. Bodie that she was looking for no more or no less coverage than she had.
But how is Mrs. Bodie supposed to know that the FAIR plan does or does? I have no idea whether the FAIR plan does or doesn't cover dogs, because there's nothing in our record that says what it does.
Well,
and nobody's discussing dogs except to say some dogs are excluded. You don't have one of them, period.
Two things. One is Mark Devine was deposed. He's part of the record. Mark Devine was Barbara Bodie's supervisor. He testified that and again, I'm pretty closely paraphrasing, we know that the FAIR plan policy covers dogs without limitation. In fact, and this is one of the reasons that the record includes an affidavit from Andrea Gwen from the Department of Insurance. She testified in her affidavit that no other company does this.
But are you suggesting that this policy wasn't approved by the commissioner?
Absolutely not. I'm not suggesting that. It was approved, but I think it was relevant, which is why the affidavit was included, that no other company in the Commonwealth limits general liability coverage. There was no asterisk, for example.
Okay. Accepting all that, it seems to me that those may be arguments one makes to perhaps negligent misrepresentation, but how does it get to actually an affirmative rewriting of this contract?
I think that's precisely where the Polaroid case comes in. Polaroid is so useful and instructive in this case because in the Polaroid case, the Polaroid company, the corporation, was looking for a comprehensive policy. And it had a policy in place with Utica National. And that policy had a pollution exclusion because to cover Polaroid for pollution would have been big dollars. And so there was a pollution exclusion for the 4 years preceding this. They decided to then shop this to other companies. They went to Lexington, and Lexington sold them a policy. And the record was clear in the Polaroid case that they were asking for and expected and intended to get what they had in coverage under the Utica policy. There was no discussion, though, about this. When the policy was issued by Lexington, it shipped without the pollution exclusion. It should have included it, but it didn't. When Polaroid was hit with a claim for pollution, it turned to the Lexington policy. Lexington came to this court and sought reformation on the basis that both parties clearly expected, and the record supported this, clearly expected that the issued policy by Lexington would have had that pollution exclusion. It didn't. The court then looked at the totality of the evidence. They looked at the negotiations and the correspondence, and they reached the conclusion that, come on, you both knew that this was going to be a policy that included an exclusion for pollution. It didn't. There was a mutual mistake, so we're going to reform the policy to include the pollution exclusion that should have been there in the first place. Respectfully, I would suggest to you that that's precisely what happened here. And if you look at the cases, they break down into two categories. You have the express variety, I call it the express variety, where we speak very specifically about what we want in our policy or what we don't, and the policy comes over differing in that sense. But then you have the circumstantial. And the circumstantial is exactly what happened in Polaroid, what happened here, what happened in the One Beacon case in the First Circuit, applying Massachusetts law. They looked at the totality of the circumstances and they said, clearly Mrs. Bodie testified, and this is what they looked to, clearly Mrs. Bodie testified she intended to sell her no more or no less coverage than she had. And this is what's so important. She thought there was $500,000 in coverage applicable here. So the conversation would never run to, oh, I need to point something out. I understand you don't have one of the excluded dogs, but you don't have $500,000 in coverage for your dog. You only have $25,000. When dog bite-related claims represent such a large percentage of homeowners' claims, that's precisely, I would argue, why
Should she
they...
have pointed out the other exclusions as well, just to cover her base, all of the exclusions and limitations,
There were no-
social host liability, things like that?
No.
Because, how would I know?
You wouldn't know, and that's the problem. In other words, you wouldn't know from anything that went on that day as to what you were being sold until later. But what's a little bit different here is that policies have, well, first of all, the questions in the questionnaire tip you off about things like that. And if you look at the questionnaire, you can kind of see where you're going down the road of no coverage. But here, this exchange about dogs would have led any reasonable person to conclude that probably one of the most popular reasons a person who owns a dog has a general liability policy is to cover an animal bite.
Didn't Mrs. Fowler testify to something that she wasn't thinking about, the limitation on liability at the time?
No, I think what you're talking about is, which frankly, I don't quite understand this point, but I think one of the things they raised is that there was no indication that Mrs. Fowler was worried at that time that her dog would bite someone.
Didn't she say that?
No, that's simply the representation of the appellant, that there was no such conversation where that was voiced. What she did say, and maybe I'm misunderstanding your question.
No, go ahead.
No, there was no discussion about that.
No, I know there's no discussion. What did she testify to in her deposition on that subject?
On what specific point? Because I'm confused.
On whether at the time she was meeting on March 10th, I thought she said something, but I could be totally wrong. You know this record and I don't. I thought she said something about that she didn't raise anything about dogs, and she hadn't been thinking about it, about whether there was or wasn't coverage.
I think that spirit is embodied in whether those are the exact words or not. I think that's fair. I think what she was essentially asking was, I think that my memory of the testimony was that there was no discussion about this, and that Mrs. Bodie certainly did not Miss Fowler did not express a concern about dog coverage. In other words, she was not expressing a desire to have this coverage in place. That's without a question. Both parties in the record testified that they both expected this policy to cover this. You would not expect this to meander into the area where there would be any discussion, because there was a false assumption on the part of both parties. They were mistaken. They thought this policy covered this, and it didn't, but they intended it to. And I guess maybe it's axiomatic to even suggest this, but I would suggest that Mrs. Bodie could not have intended to sell a policy about that with a provision that she couldn't conceive of. I mean, she's admitting she always believed that the $500,000 limit covered this particular risk.
But a policy contains all kinds of exclusions and amendments and endorsements. If you're right, does that mean that when injury occurs or damage occurs and you look at the policy and the policy doesn't cover it, in every case you call the agent up and say, did you know that this policy had this exclusion? And if the answer is no, you bring a claim and saying it's mutual mistake?
No. I think that there are, and the cases have addressed this very point. In fact, I believe that in the fireman's case, this exact issue came up, which was that there was a policy for health insurance coverage sold, and there was clear misunderstanding, or strike that, in the underwriting process. There was some irregularities, and they raised the question in that case, well, come on, if we start doing this subjective thing, if we start saying, well, if you don't understand it, you can come back later and say, you never told me that, and then suddenly the coverage would be in place. The court was very clear about that. They made a wonderful point that really the safeguard for that lies in the application process. And that's really at the heart of this. One of the flaws in this process I suggest, and we addressed this in the brief, is the application process. The fact that a contract is being negotiated which isn't in the room, there is absolutely no way that a consumer can sit there and know what she's buying and what she's not. And here she's guided by an agent who is, through that questioning about the dogs, and who is admittedly, and this is a rarity, you're not going to find in too many cases, an insurance agent who says later on, to be blunt, I thought she had that coverage. Once you have an agent who's of the mind that she's selling something specific, then the questioning is molded around that question.
But isn't there a certain adoption once the policy is sent and not canceled?
That it's accepted on its terms?
Well, because you do, if Mr. Gallagher is right, if you get the policy and look at it and say, I didn't realize that it did not cover this, I don't want a policy that does not cover this, you can cancel it. But she saw the policy, she skimmed it, didn't say, I'm shocked to learn it does not cover my dog beyond $25,000.
I would suggest to you that Barbara Bodie, as stated in the records, has been doing this for 14 years. She was looking at that same exact policy and its endorsement for many, many, many years, and it never jumped out at her. And I would suggest to Your Honor, when you look at that endorsement, ask yourself if it seems clear to you. I'd respectfully suggest that it was certainly not clear to us when we read it. It wasn't clear to the person who was selling it either.
All right, counsel, thank you. Your
Thank
time
you.
is up.